morning. This is case D-516-583, Crane versus Sevilla, set today on plaintiff's motion for joint legal shared physical custody under Druckman versus Rashidi and child support under Rivero versus Rivero for mediation in good faith, neutral exchange location, judicial notice of defendant's abusive process and perjury before the court to consolidate and dismiss the TPO, to prohibit mom from leaving Nevada with the minor child, award of fees and costs to the plaintiff. Defendant has an opposition and counter motion, and plaintiff has a reply that court has set today for a case management conference. Counsel, kindly your appearance for the record.
Good morning, Your Honor. Amber Robinson, bar number 10731, unfundled stay on behalf of Stanley Crane, who's present.
Good morning and welcome. And Brandy Sevilla, you are defendant mom representing yourself, correct?
Correct.
And you have an older child. What's your older child's name and date of birth?
Zoe Warder, date of birth, August 15th, 2002.
I just like to know that kind of stuff for, sibling issues. I have some issues. Dad has a bench warrant out right now since 2013. So, and Dad has a long criminal history, going back to age 17, with domestic violence and battery and violating a domestic battery, violating a restraining order. A lot of traffic violations.
Yes, there are a lot of traffic violations.
Now, the one that the bench warrant's on is a traffic violation. So the policy of the court is not to take you into custody the first time I see you, but when you come back, if it is still on the computer and you have not, hopefully it's just a fine and you pay it. But since it's since 2013, I'm not positive what they're going to do, but you need to get down there and pay that fine. Because next time I see you, if it's on the computer, you have to be taken into custody.
Yes, Your Honor.
I want to give you a fair warning on that. All right. Let me see here. I do not have an FDF on Dad's wage statement. Does he have one with him? Or if not, I'd ask him to update his FDF.
That was just filed yesterday, Your Honor, so you should be able to pull it up.
With the supplemental wage statement?
Oh, with a supplemental wage statement. I have
his FDF from the 19th. I just don't have but he just started working at this place May 20th. So, but he should at least have a couple wage statements.
He's going to get 2 more from his employer, but I have the most recent one.
Okay, so when we get to that, I'll ask you
Okay.
to let me see that. All right, I'll let you, there is a TPO active right now through March 10th, 2016. And I will let you, and Dad's paternity was found in the R case, so it's not like we have to go through that stuff. There is some confusion with the R case hearings, and I'd allow counsel to argue, then mom to argue, counsel to reply, and then we'll figure out what we're going to do today.
Okay, Your Honor. Just to give quick background on Mom from what Dad knows, she does have that 13-year-old daughter that she just spoke of, and she's alienated that daughter from her father in California. There was a second ex-husband, that dad is in Arizona. There's a second ex-husband in California, and what she told my client upon moving here is that she just had to get away from him. And she had just filed bankruptcy at that point. She is experienced with the court process, what she needs to file, and so here, when the parties were pregnant, she files a TPO against my client. That goes into court. They end up getting back together as a couple, and when they return to court on a return court hearing, she told Judge Kearns, "I've not had any contact with him," which was just blatantly lied to the court. Several blatant lies that she made statements to Judge Kearns, and my client had text message communication between them that proved otherwise. Long story short, ultimately this case has been dismissed. She tried to get him to violate the probation that he was on through that case, and when Judge Kearns wouldn't have it, because again they had reconciled as a couple, she then goes over to family court and files a TPO here. She filed a TPO last year in family court that was dismissed. So Mom, we feel, is abusing the TPO process, and just to get a leg up in front of Her Honor. When the parties were living together since the baby's birth, my client was actively involved. He cared for her first 6 months. He was on unemployment the large majority of that time, so he was the caregiver during the day. For the first, what was it, month, 2 months, couple of months, when he was still working when she was born, he would work all night, come home during the day while Brandy was gone all day at work, and care for her during the day. So he's always been actively involved in her caregiver. The parties stayed together in a relationship until October 2014. They lived together. They were joint custodians. And even when they separated towards the end of October 2014, they continued to have a sexual relationship until February 2015. During this time, Dad had their child Autumn at least 3 days a week, and then the parties continued to be involved, and so they would spend weekends together as a family. It was when she became upset again that she then marches into TPO court and has cut off contact with Dad. The order from the TPO court was that Mom could have discretion as to when Dad could see the child, and that has resulted in Dad not seeing Autumn for 4 months now. We are asking for the court to put in place joint legal custody, Your Honor, joint physical custody. This is the initial hearing. He has been a joint caregiver. We understand that there's a lengthy traffic history, criminal history, but this does not go towards how he can parent his child Autumn. With the custody that we're asking for child support to be adjusted pursuant to Wright v. Osborne, and I have the exact numbers I've calculated out what his child support should be, at least what he would owe under Wright v. Osborne. I don't know what Mom's income is, but his year-to-date is $4,560, and that was him being hired around May 20th. So I divided by 13 and a half weeks, giving him a gross monthly income of
How do you divide between May when he was employed until now?
Right. Then I multiplied that out by the 12 months to then get the gross monthly of $1,463. We're asking for compensatory time too. He's gone months and months and months now without seeing his child, and we would like makeup time. And we do know that the parties are going to have to start doing exchanges. We do feel that Mom, like I've said, has abused the process, so we would like neutral exchanges, whether that's at a McDonald's in between their homes, whether that's down here at the courthouse, just somewhere where my client doesn't have to worry about her going and filing another TPO. It would probably be appropriate to also put into place our family wizard. Mom needs to learn that she needs to communicate with Dad about the child's whereabouts. Like, he doesn't know exactly where she is for daycare. He's not updated to health concerns for their child. He is an equal parent. He should be given equal time. And with that, I'll let Mom respond.
Before you sit down, or you can sit down and answer this, the case from 2013, the battery DV, do you have proof of the criminal records with regard to the dismissal, the hearings, the minutes, or anything like that?
The most recent one, the dismissal.
Yeah, because to me, I don't understand if there's their 2013 violation of the restraining order. I can't imagine that's from 2002, which I think was a conviction, wasn't it, for battery DV? No?
So this case that she's talking about, is this a different case than the one with Brandy?
I've never ever been convicted of domestic
You are
violence.
Stanley Randolph Crane,
Yes,
correct?
ma'am.
Okay.
Yeah.
Well, these are all your criminal records.
Yeah.
I have the case. Yeah.
I'm not aware of this case, Your Honor. What's the case
It was
number?
Battery DV case C05112995A, a DUI in 2006, C0661879A. A lot of speeding. I'm not going to go over all the traffic violations, but it's 060606 2011, and then the 2013. Then there's a 2013 case C10978755A, violating a restraining order, and a 2003 C10981992A, battery DV. So also there was a drug, apparently a drug-seeking theft crime. petty and grand larceny back in 2002, and, you know, if he's not using drugs or alcohol now, I'm not gonna hold that against him. However, I think a drug test needs to be taken today based on Mom's allegations. Is he willing to do that?
If I must. I don't understand why my entire history is coming into this. I mean, I've done...
Because it's the first time I've seen you, and a lot of this stuff goes to parenting fitness, especially domestic violence and DUI. Those are, I mean, if you don't think that's a long criminal history, I have concerns. You started this stuff at 17, and you're 32 now, and you're still having run-ins with the police.
We do
have a bench warrant out for your arrest.
We understand the court's concerns, Your Honor.
When you have a bench warrant out for your arrest, if the child is with you, the child goes to child haven.
I understand.
So these are concerns.
I understand.
It's not that you can't straighten things out. It's not that you can't. I mean, if you have never done a domestic violence intervention, I'd ask you to do one. I'd ask you to do at least the minimum 28-week one through options, where it's a group setting, where it's not a class. It's where you're in a group with people, and you know you're confronted by each other regarding how you handle things, and increases your coping with impulse control and anger. I don't know what the criminal courts had you take. I'm trying to find all this out because all I know is what's in that computer letting me know what's happened in your criminal past. I'm a judge who leans toward joint physical, absolutely, whenever I can. But when I see this kind of a criminal history and a bench warrant and having involved with, you know, substance abuse and driving, and I see a 1.5-year-old little baby, I'm going to be worried because I don't know if you're following rules and regulations when you're continually speeding. Even into 2013, you have this bench warrant for a traffic violation, which I don't know what it was. Do you know what it was?
It was illegal parking at the airport. I hired the ticket busters to take care of it. I ended up moving before I got the notification when I was supposed to pay it in court. And lately I've just been spending all my money on legal fees and child support just to be able to make sure that when I came into court I was almost valid.
You don't want to get picked up on a bench warrant and go to jail.
I understand that, ma'am.
He wasn't aware of the bench warrant, though, so I'll have him get on that right away.
Okay, let me listen to Mom, and then Amber can rebut or reply, and I will then talk to you about all the orders I think we should make today.
Okay, good. In response to all of that, Your Honor, my 13-year-old daughter has never been withheld from her father. In fact, he has written a letter, a notarized letter, stating that we have a very good relationship, we have a very open relationship, and she just got back from visiting him this summer. She was with him for about 4 weeks. So I've never withheld visitation, and I do have that proof here. Regarding my ex-husband in California, me having to get away, which was said, is completely false. I lost my job in California, and I couldn't find another job that paid what I was getting paid. I had to file bankruptcy because of that, and also I lost my husband's income, of course. So, you know, I had to file bankruptcy, and I don't see what that has to do with anything, as I am very stable. The statement that I'm experienced with court is false. I've never had to file anything like this in my entire life until I met Mr. Crane. I've never been in and out of court as much as I ever have, besides work-related, until I met Mr. Crane. This whole confusion about TPOs and Judge Kearns, I would like to read this as I'm getting off track here. The restraining order needs to stay in place for our protection due to the recent closing of case C-109-8192A on August 10th that had been open since July 2013, as this had a stay out of trouble order for 2 years, or probationary period for 2 years. Stanley Crane.
He's on probation?
He was on probation for 2 years, yes.
From the 2013?
Correct.
Okay, go ahead.
Stanley Crane has proven to be high conflict and cannot control himself around me or my daughters. I've given several chances to keep it peaceful and visit with our daughter with Judge Kearns' approval for contact on our court date, January 20th, 2015. May I state also, I never testified in front of Judge Kearns to be accused of perjury. That never happened. And city attorneys told me that you can get the minutes, and they do have proof of that.
You can get the minutes. I don't get the
Okay.
minutes. Courts can
Well, I never
take what comes
testified.
before it in a court of law. We don't investigate.
Okay. So that is a false statement. I once again became hopeful he would change and partake in our daughter's life peacefully. But Stanley increased his level of violence with me in front of my children, despite Judge Kern's warnings and completion of court-ordered anger management classes. When I decided to end all contact, that was on the DV case March 1st of 2015, where he tried grabbing me in front of my children and slamming my car door in my face, and it was just awful. I ended all contact. He called me up to 55 times a day. He stalked me, harassed me, and trespassed my property by jumping my locked gate 3 times, demanding to speak to me. My brother actually had to come out and make him go away, and I had to call police. This resulted in a 3rd restraining order set in place, this time for a year, which he now wants dissolved. I journaled every day and kept log of all visits that happened in those 5 weeks of contact with Mr. Crane. He never had Autumn 3 days a week. I quickly realized after being in the cycle of abuse every 6 to 8 days that it is not in the best interest of myself or my daughters to be around Stanley, as he tried to control me and continue to abuse me while minimizing the abuse I suffered by him. I and my daughters are now happy, we're healthy, we're free of abuse, and this is because I realize he will never change because of the restraining order that's in place for our protection. So I request the sole legal and physical custody of our daughter due to continued domestic violence with me despite my children's presence. I do not feel safe or feel it safe for Autumn to be around Stanley or his family due to the emotional abuse and violence they demonstrate. I do not feel it safe for Autumn to be alone with Stanley after the photos he has taken of himself while she was in his care. There is a CPS case number on that. After reading the falsified statements he wrote about me in this custody paperwork and being chased down in my employer's parking lot by his stepfather just weeks ago, I do believe he is still drug addicted. He is still affiliated with drug users, as he sent out his meth addict girlfriend, Deborah Wickham, and I do have her picture right here, to my job to serve me custody paperwork. And she was recently charged with child endangerment and with her own son, and was booked on drug charges December 2014. Stanley knows how to pass drug tests. He's collected urine from her son, her 8-year-old son, in a baggie and taped it to the inside of his pants to pass. Stanley denies and minimizes his violence and abuse with me, usually blames me, brings up my past that he wasn't even a part of to try and hurt me. He lies about events that have taken place between us and other people, including Judge Kearns and my oldest daughter's father. Because of these false statements, I have notarized letter from Mike Warner, whom is Zoe's father, to disprove his accusations of non-visitation these past 11 years since our divorce. And to make record straight, I already said this, I never testified in front of Judge Kearns to be blamed of perjury. So in ending, this has been the most stressful and most painful thing I have ever gone through. I've never imagined myself to be a victim of domestic violence. I wanted nothing but the best for my daughters and to co-parent peacefully, but that cannot happen when someone is abusive and manipulative as he is, and has parents that are the same way that enable his behaviors. I will now protect my daughters as much as I possibly can and provide the best life possible for us without violence, without manipulation, and without abuse ever again. So that is my response.
Amber, I forgot to say he has over 25 cases, traffic cases. I didn't list every one of them. I'm saying there's over 25. I've never seen that many in any case in 12 years.
And we understand the court's concern for the traffic violations, but they are traffic violations, Your Honor, and they do predate the birth of Autumn. And I don't, while you're concerned, I don't think that they are too relevant to custody.
The TPO that's currently in effect, I think, is also, I kind of agree with what the hearing master said, that, you know, it supported the applicant and extended the order because she tried to get one several times and felt that it was warranted to extend it. So what I'd like to do is have Dad do, he's going to do the drug test, hair and urine, no use of adulterants, no shaving of body hair by 11:45 a.m. I'd like him to do the 28-week DV intervention at options. If his drug test is dirty, then I want him to wear a patch for the 12 consecutive weeks that my policy is 12 consecutive weeks, clean patches, because it's just going to pick up new use, not anything from the past. And if he can get 12 consecutive patches clean, then, it would be supervised if he's not clean. I'm okay with giving him his days off with maybe Donna's house exchanges so that they don't come into contact with each other, because they are high conflict right now. And I think there's a lot of immaturity and impulse control issues. All I can know is what's been filed and what I've seen on Odyssey, and I'm sure there's a lot more for me to know. But I'm not willing in this case to jump into a joint physical. I am willing to consider that if he's clean and he does the DV intervention. It's not an anger management. It's a counseling group. It's a intervention designed to change the way that you handle conflict, not just a class where you absorb information. He also has to prove that his warrant's been quashed before he is given time with the child, because if he has another speeding or traffic violation, the child could go to Child Haven, which is not a good thing. I'm fine with our family wizard, and my marshal will hand out our family wizard information. It's $99 a year. Each parent will pay for their own and set it up. I would ask that. Are you unbundled, Amber?
Yes.
Well, I would lift the TPO for purposes of communication through our family wizard. And if there's an absolute emergency and there's a text, I'm on the way to the ER, this is what's happened to the baby, that's not going to be a violation of the TPO. So emergency communication by text regarding something like that, or let's say you're trying to get to Donna's house to do your exchange, you have a flat tire, you're stuck in traffic, you can text the other parent and say, my ETA is this time because I'm stuck in traffic. That will not be a violation of the TPO.
Can you explain Donna's house?
Donna's house is here on our campus. You each would have to take the orientation. They'll explain that to you downstairs. I'll give you an order for Donna's house. I just want to do it until you guys can get along better. I really feel like you're in a position right now where there's fear and trepidation on the part of mom, and frustration and anger on dad's part because he hasn't been able to see the child. And if he was taking care of the child during the days when mom was at work, then I presume he has a very good bonded relationship with her. You don't agree with that, Mom?
No, I do not.
You didn't respond to that, so I don't
I'm
know.
sorry. There was so much that was being said that no, I don't feel that any longer. He had in my police reports that were filed, he was rough with her at night when he couldn't get the sleep that he needed and would shove her away and would yell and scream in front of her. He's violent in front of her. And no, I do not feel it's safe whatsoever for her to be around him at this time, or any member of his family, due to the harassment and the libel on the internet from his mother. And I'm not exactly sure, ma'am, what type of exchange, whether this is a visitation for a couple hours or if this is for a day or two.
Exchange is just it would just be an exchange of the child. You can't limit him from maintaining a bond with his child. If he comes back dirty for drugs, he has to have supervised visitation. At that time, if you guys cannot agree on a suitable supervisor, then Dad can get a Donna's house order based on when he's available and when Donna's house is open, until he's got his 12 weeks clean. But right now, I don't know whether it will be supervised until we get the drug test results back. So
I would prefer it to be supervised due to the photographs that he's taken of himself with our daughter on him.
Your Honor, she hasn't submitted any evidence, and she's made a lot of self-serving statements here. The court has given her orders.
I have Detective Madsen's card. There's a CPS case number.
I forgot to say that we've asked for CPS records. We're waiting on them, and both sides have the right to come to the department and review those. We like you to do it when we're in court. We'll be in court tomorrow all day. If you want to come in and ask the marshal, to look at the CPS records if we have them. Usually we'd have them by now, but we didn't get them.
The reference CPS case has been closed.
Oh, it has?
It was closed in March, I believe. That's when I did my interview with Detective Madsen, and since I had the restraining order that was approved, he said that I didn't have to worry about it. I pretty much mitigated the situation by removing my child from his care.
that. If they find that the child's safe, they don't usually continue.
Right.
What's a phone number that Options can work with Dad with?
702 815 5560.
815-5560?
Yes, ma'am.
Okay. To me, oh wait, no, that's the wrong thing. Are you gonna be dirty, Dad?
No.
Okay, good, because I would just order it now and you could get started. I just wanna give you a chance if it's going to be dirty.
And Your Honor, we do have an open child support order. It's already, I have all the paperwork here.
I'm gonna leave the child support, I've seen both of those, okay? Minutes from both of the hearings. The one, it's a little confusing, and I'm gonna clarify that for both parties. At the first hearing in March, before, oh no, I'm sorry, look at the TPOs. The first hearing in April before, Hearing Master Tootin, it was discussed that Dad should have a contribution of $41 per month toward health insurance and $60 toward daycare costs. And then it says arrears are fair and reasonable at $120, R $480. So I have no idea what that means, and so I'm ignoring that because the next hearing on June 18th, 2015, Dad had Nicholas Delvecchio, and he had a job $10 an hour. So now he's earning $1,033.33. 18% of that is $312, and he's to pay $312. But they did not go ahead and add the $41 for the half of the health insurance. So what I would like him to do is pay the $312 plus the $41, defer on any help with childcare because I don't think Dad can afford it, but he definitely by law needs to pay the $41. So it would be $312 plus 41 is $353, and if he wants to divide that into two payments to make it easier, he can. Amber, can you ascertain what will make him successful?
I've actually been paying $373 a month, Your Honor.
Yes.
So you have been paying the
Paying
daycare,
$373 a month.
and you're able to do it?
Well, the way I calculated it out though, his child support without the extra should be $263, not $312.
Well, that's a standard. I mean, if you multiply the 18%, it's always $311.99 or something, and it's $312. $10 an hour is $1,000.
Well, right, but he doesn't work 40 hours a week. They base that off $10 an hour, 40 hours a week. They keep him right around 35, between 30 and 35, because they are at, he's about to get out of his probationary period with his work, and they're trying to avoid paying him health insurance, so they keep him between 30 and 35 hours. So with the paycheck stub that I provided, it calculated out to $1,463 a month, which is 18% is $263.
Well, the thing is, he needs to be working full-time at his skill level, like Mom is working full-time at her skill level, right?
Yes, ma'am.
Normally, I would just impute the remaining hours to him, and I don't think it would be a 20% change from June, and I don't think he's filed any objection to the MRAO, which was filed on July 10th, 2015. So I'm not inclined to change that, but I am going to add the $41. And so, Dad, you don't have to pay the amount you're paying. You just need to pay $353, not the $370, whatever you've been paying.
So $353, would it be better to pay it twice a month?
Your Honor, that $20 difference is the arrears payment, which we do have a court hearing December 3rd, I believe, for me to prove the arrears.
Okay, so is that the arrears payment, Dad?
Yes, ma'am. I have the order right
I want
here.
Dad to respond.
I was told that I was caught up in my arrears. I was finished paying that off when I was working.
They don't make it clear what the arrears are in the minutes, so I can't tell. So if you are supposed to be paying their arrears, Dad, then I would ask that you add the $20. If you're not, the thing is, what they did was they deferred arrears to the family court. But I'm not willing to have it deferred to me because the district attorney can investigate. And if Dad is saying he had the child during the days, I mean, how far are they expecting to go back? When did you guys separate?
Well, I think she would like to go back to August 2014. They didn't separate until the end of October 2014, so arrears.
September 30th.
So arrears, if she wanted arrears, would start November. But my client in that time was caring for her 3 days a week. He gave mom cash payments, also was providing diapers and food.
So let me differ on arrears, because if I'm going to have to try it and find out where the child was, the child support court doesn't try things. When are you saying you are separated?
I moved out as of September 30th, 2014. The relationship ended August 19th of 2014, and she started her daycare August 25th.
When you moved out would it be the time frame?
September 30th.
Okay, so mom says September, dad says October. So we'll defer on arrears and arrears payment. So dad, just pay the $353.
Just on that note, Your Honor, she left him responsible for the lease that she was equally responsible for. So he was also paying that as well. And we dispute that it was September 30th. It was end of October.
I deal with that later. I still have really tough cases. One is another one of yours.
I know.
And 4 of them at 11, and now it's 11:15, and I have drug court at 1. So I won't have time to go over this stuff in detail. What I do want to do is set a counter call and an evidentiary hearing, have them do Donna's house exchanges. Dad, what are your days off right now?
Technically, I don't have a day off. I haven't had a day off in 3.5 months except for today and yesterday.
So what are the hours that you work?
I work anything from 5 to sometimes 10 hours a day. I just had 4 employees quit the past 4 days, so I've been around the clock.
How can you work less than 40 hours a week and work 7 days a week around the clock?
Well,
They'll schedule me 5 days.
Very inconsistent.
It's just
Let him
happened.
try to rehabilitate himself.
This just happened 4 days ago, so it's just been the past 4 days. Before that, I would work 4 hours a day. Sometimes I would work 5 hours a day. It would vary into where I would go home for a 6-hour period. I'd go back to work.
His employer did state she would work with Your Honor's orders because she knows that she's been working him to death and that we were expecting to have some visitation today.
What are
And
mom's days off?
I only have Saturday, Sunday off. I work 8 to 5 Monday through Friday.
Okay, so he's not going to have visitation today because he has to take care of his warrant. I want to set a quick return, like within a week, so I can look at the drug test results. If those are fine, then it's going to be unsupervised, and you talk to your employer about whether you can get a standard couple of days off, even if they're not together, so that I can set something that works where you guys don't have to communicate all the time because things are changing all the time.
Gotcha.
You can get days off that are different than mom's. That will give you more time, because if people have the same days off, I have to alternate those days because you can't take it away from the other person.
I understand.
So bottom line, see what you can find out from your employer, get the drug test done, and can we come and proof of warrant, bring back the proof that the
I'll do
warrant's
that
been
today.
quashed. Okay, good. I hope that's not an exorbitant amount of money. And we'll do a temporary joint legal primary physical to mom. Dad's visitation is deferred until I can get back here on the drug test and the warrant being quashed. And I'd also like to see proof that you're signed up, Dad, for the options program. That'll make me feel a lot more comfortable. There you go. I didn't put a return date on there, but I'd like to put the earliest return date we can. Do you want me to look at my calendar too?
I'll put it on for next Thursday.
Can you do that? Do I have room?
Your Honor, respectfully, this options is an extra expense, extra time for my client when there has not been a criminal conviction in this matter.
Yeah, but he has had a long history of domestic violence.
Well, but I think the DV case that you're referring to is this DV case with Brandy.
He doesn't have to. There's also one prior and a DUI. I mean, if he doesn't want to take it, I'm going to be less likely to give him joint physical because he's still having problems in 2013. I know he's saying she's lying, but the TPO commissioner decided she wasn't, and nobody appealed that. No one objected to her decision and came in here within 10 judicial days. So I'm not going to relitigate that aspect, although domestic violence, I mean, in terms of granting that TPO, but domestic violence is at issue for the trial, and all of the domestic violence information that's ever occurred, is going to be grist for the mill, as well as, both of their histories. He's got a long criminal history, over 25 traffic cases in the past 15 years, DUI, two, where's my list? He's got the larceny, petty and grand larceny. He's got the drug issues, violating the restraining order in 2013 and the battery DV in 2013. I don't have records on that. I'd like to see him bring back records from that criminal proceeding so I can see what's going on. If they're asking him to do something on his own there, then I would probably agree to that intervention if it's long enough, because he needs to change the way that he handles things.
They had that. I did 6 months of impulse control for Judge Kearns. The reason that
Then just bring me that proof.
Okay.
Bring me the proof that you did it.
We can bring that to the return hearing.
Okay. So arrears deferred, and the findings relative to who had custody since separation and when separation was also deferred. And health insurance, mom's providing, dad's splitting that cost. Uncovered costs will be shared equally under what we call the 30-30 rule. Amber, if you want to, because I'm going to ask you to draft, but or you're unbundled.
I'll draft the order.
It's just, are you going to be coming back in a week on Thursday? Because if so, you might want to just draft one order.
Okay.
Is she coming back with you, Dad?
if I can afford it.
Okay, so if she doesn't, I can have the department prepare the order, because I made some orders today that will survive. Do you know what I'm saying? They'll survive past the following hearing. There was another issue about sex tapes. I forget where I read that. That's not true.
Sex tapes?
It's just
I
fluff.
think it was in your pleading.
It was
just fluff.
It was in his pleading.
Were those taken with consent, or were they secret? Because if they weren't taken with consent, they have
She
to
made
be
the video.
No, I did
Picked
not.
up the
That
phone
is
and made the
false.
video. I can bring the evidence in and show her picking up my phone and finishing the recording. It's on video.
This was a time of no conflict, Your Honor, and this has nothing to do with our child.
This was 2 days before you filed the restraining
I'm
order.
just trying, he raised it, so I was just trying to figure out whether that was something that should be dealt with in court or not, but it sounds like it's not. All right, so I will see you guys Thursday at what time?
Okay, I'm giving two return dates. Stuff, and then I have a calendar calling the trial.
Okay.
So your first return date is August 27th at 9:30 a.m. to address the drug test and the warrant. The second return date is October 15th at 9:30. Your calendar call is December 1st at 11 a.m. And the non-jury trial is December 15th.
It'll be evidentiary, sorry.
Is December 15th at 1:30.
And their stack what?
There is no staff.
Yeah, so they're number one?
Yes.
Okay, what is our second return for October 15th again?
She was in on the Valley House, exchanges of voting, and
Okay, let's take that one off first, and because if he comes back and he's clean, he won't be doing options. And then I can probably set it up, I'll figure out whether Donna's house works or if there's some other neutral way to do it.
Are the parties going to mediation, Your Honor?
Well, I don't think this is a good case for it. I wrote a question mark with DV protocol, but if mom's not comfortable, are you comfortable trying to mediate?
No, I'm not.
From what I read in the case, I really don't think I did. That's why I didn't raise it. But I appreciate you asking, and if they change their mind, they can always get an order from the court. So these are temporary orders without prejudice, and I'll see you guys back here Thursday at 9:30 relative to the warrant and the drug tests.
Your Honor, do I need to appear for that one?
Pardon?
Do I need to appear on Thursday?
Do you need to appear?
Yes.
You can appear by phone if you have to from work or something like that. But you do need to appear.
Okay.
Okay. Have a good afternoon.
Dogs?
Yeah, sure.
Dodds is next, but I have a question